May I please, Lordship?
Yes.
With consent of respondent side, item number 15, maybe adjourn.
Item number
15,
15.
1.
Item 15 on the request made by Mr.
L Deca.
N. Deca.
L Deca.
L. Deca. For the petitioner.
Yes.
Stands adjourned to be listed after 2 weeks. Yes.
Lordship was pleased to fix this matter on 3rd of December, Lordship.
Which one?
This is not listed today. I'm praying for listing of this matter on Tuesday, Lordship. Lordship, yesterday I made some mistake, Lordship, in my statement, Lordship, that there's extension has been given up to 4 months.
You want it on Tuesday?
On Tuesday, Lordship. Monday or Tuesday?
All right. All right. You give a mention memo.
Lordship, I'm giving, Lordship.
Maybe.
Obliged, Lordship.
But item number 14.
You please inform the council for the petitioner. Also.
I have already.
But item number 14. But this is I am help by the government for coordination of delay. I need some time, madam, for more people.
Item 14 on the request made by Mr. S.P. Das stands deferred to be listed after 2 weeks. Yes.
Like to mention item number 1. May please, Lordship, may I kindly pass out for the day? Because my senior
Item
is
1
out
pass
of-
over on the request made by the council for the petitioner.
Also mention item number 9. I need 1 week's time.
9 on the request made by council for petitioner. I am in. Adjourned for 2 weeks.
May I please, Lordship? I beg to mention for listing of an admission matter, my lord. Petitioner has been suspended from service.
Suspension matter.
Dismissed from service, my lord.
Oh, dismissed from service.
Yes, my lord. Next Friday, if possible, my lord.
Hmm?
Next Friday.
Not next Friday, 27th. 27th November.
That if possible, some earlier date, my lord. From last 1 year, matter is pending. They have not filed affidavit, my lord, even
13th.
August.
13 November. Yes.
Lordship, I am praying for listing the matter. Matter relates to Lordship pension, Lordship. On 7th, Lordship.
No pension for what?
Admission, Lordship.
Admission matters.
Yeah.
Pleadings exchanged.
Lordship, the matter of 2024, Lordship.
Affidavit is being filed.
They have not filed. Lordship.
Not filed already. 7th.
7th.
Not 7th. 10th.
Yeah, all right.
Item 1, someone made a mention here.
I'm for the petitioner.
Somebody made a mention. I thought you were for, he mentioned it for the petitioner.
No, my lord.
Huh?
Item 1 should ideally just go notice because there is an arbitration petition.
That's right. So I was wondering why the petitioner is praying for time.
No, my lord, I am the petitioner.
Oh. Who knows this often? You wait for some time. Who knows this? Always out. Don't you buy a as a matter?
He's for the respondent, he's for the railway.
It's for the railway.
He's for the railway
Please inform him. Please inform him. We'll take it up. None appears. Item number 2, when the matter is called up. List after 1 week.
Item 3.
None appears for the petitioner. List after 1 week.
May I please, Your Lordship? My lord, the matter here is I am currently posted as Deputy Marshal in the Assam Legislative Assembly Secretariat. Now, my contention is that the post, when it was created, it was a gazetted post. And the scale of pay that was given at that point of time, in subsequently, when revision occurred, there has been error in
What
it.
is your prayer here? What is your prayer?
To direct the respondent authorities to consider my post as a gazetted post, firstly.
This will require response from the other side. We'll issue notice here.
Yes.
My lord.
Third council for parties issue notice written ago 4 weeks. Mr. T.C. Sutia, learned senior government advocate, appears for all.
1 to 5 and 7. 6 is finance department.
1 to 5 and 7. 6, Mr. P. Nayak appears for respondent number 6. Since the respondents are represented, notices are waived, extra copies will be furnished.
My lord,
within a period of 1 week from today.
my lord. Obliged, my lord.
Obliged.
None appears for the petitioner on poll. Mr. A. Chakraborty appears for the respondent. Yes, next week.
আপনার
My lord, the petitioner had not been getting his salaries for the past 40 months, my lord. So on the matter had come up on prior two occasions on 22nd of September and 25th of September.
What
Yes,
instruction?
Lordship, instruction is 1 week more required, Lordship. Today morning, I have communicated with the officer, Lordship.
Mr. M. Sharma for the petitioner, MS X. Borwal and a government advocate, renews our prayer for further time. List this matter again after 2 weeks.
My lord, maybe after a week, my lord, on a fixed date, my lord, because the petitioner is facing
Give them some time, get your instructions,
she has to,
instead of adjourning the matter on every day.
my lord, my lord, on a fixed date, my lord, if I may pray for a fixed date, my lord.
Yes, fixed date.
Yes,
On 17th.
17th, I'm grateful, my lord.
Lords,
Wait, please, Lordship. Lordship, as far as earlier dated, Lordship, the respondent side took time for discussion and submit the register of the survey.
What is your grievance here?
Lordship, the petitioners applied for the Anganwadi worker, Lordship. The responsible authority rejected the application of the petitioner, Lordship, saying that the petitioner are outsiders,
Petitioner is an outsider.
Lordship.
He has any instruction?
No, my lord. Notice by issued, my lord.
No, why notice? There is already an order directing you to.
Yes, but we have not received, we have sent letter, my lord.
Huh?
We have sent letter, but
Alright.
we have not received.
Your name?
MZ.
Mr. MZ Shah appears for the petitioner. Mr. T.C. Sutia, learned additional senior government advocate for the respondent. Stop Mr. Sutia renews his prayer for further time. He prays for 3 weeks' time. List again. Prayer made is allowed. List again after 3 weeks.
Notice may be issued, Lordship. Last occasion,
No,
Lordship.
let us see, because there is already an order. Had it been a fresh matter, we should notice. There are already orders directing me to file. He is renewing his prayer. 3 weeks.
Bless. May I please, Lord? My lord, in this case, the land of the father of the petitioner was acquired with an assurance to provide him a government job, my lord. And according, his father's name was recommended. But due to lack of technical qualification, my lord, a job could not be provided to him. Now, my lord, petitioner has become technically qualified, my lord.
Who is for the ONGC?
My lord, there is no council, my lord. After no,
You serve copies.
no, my lord, there is no standing council, my lord. Once notice is issued, my lord, then they appear, my lord.
one more thing.
8.
No, this assurance is what? What assurance? Verbal assurance.
My lord, only see page 12, my lord. There was his name of his father was already recommended, my lord.
Recommended for whom? Recommended for what?
For
Employment exchange.
no, my lord.
Uh,
Landowner, which was under occupation.
Registered, his case has been recommended. Deputy Commissioner, where is the ONGC's recommendation?
My lord, and similar,
Your synopsis says ONGC authority is assured.
yes, my lord.
Then where is the assurance?
His copy is not available with the.
They're not available. On what basis you are filing this case?
My lord, let them come and say, my lord, if there is no provision.
Why will you even trouble them to come and say, when you have to establish something that this is my right? I have demanded, they have not given. You have to crystallize your rights.
In this regard, representation was fine, my lord.
Representation is not an issue. Why will they consider your appointment like that?
Let
This
them,
is a public sector undertaking.
let
There is
them
a process for recruitment.
if there is no provision, they will reject, my lord.
No, it's not a question of provision being there or not there. It's a question of their you have stated in your synopsis, they have assured.
Yes, my lord.
Where is that assurance?
Assurance, it is a long payment, my lord. Assurance copy is
Then
not available.
76, there is an assurance. How do you want to go ahead? What is the basis? Tell us.
And,
You can't reduce the High Court to that of a panchayat. You think about it. Matter be listed after next week, listed next week,
obliged.
enabling the council to complete his instructions as to the right of the petitioner to be considered for employment under the ONGC on the basis of some assurance given by ONGC to his father as far back as 1976.
Yes.
The petitioner will address the court on the question of his entitlement for for the direction sought for in the present writ petition against the respondents. List only accordingly.
Obliged.
May it please your lordship, the petitioners are retired employee of APDCL and AEGCL. Lordship, they are seeking lordship all service benefits from the date of their initial appointment, lordship. At this stage, notice may go, lordship.
Let them obtain instruction first, whether they are entitled, not entitled.
Lordship,
Get your instructions, heard councils for parties. Standing council, APDCL.
But I'm appearing for the APTC.
APDCL is also there, AEGCL is also there, lordship.
Standing council for APDCL and AEGCL will obtain instructions with regard to the claims for you want area salary,
Lordship, no, all service benefits from the date of the initial appointment, lordship.
claims of service benefits from the date of their initial appointment as security guards
Lordship,
under the erstwhile Assam State Electricity Board. Although stop notices are not issued in order to enable the respondent councils to obtain instructions, extra copies, sufficient extra copies of the writ petition be furnished to the respondent council within a period of 3 working days,
few working days, lordship.
least after 2 weeks.
See, only 2 are retired, others are working, lordship.
Service benefits of the writ petitioners during their service benefits of the writ petitioners for rendering their service under the erstwhile so and so. 2 of the writ petitioners have also since retired from service. Yes.
Lordship there,
After 2 weeks,
lordship. Immediate,
you want date?
lordship.
28th
Lordship,
November.
lordship. Obliged, lordship.
Extra.
May it please your lordship. Lordship, this matter relates to an association of medical laboratory technicians, your lordship. Lordship, they are spread out across Assam and their job primarily relates to managing medical laboratories, arranging test results,
and making sure that the medical system functions to its best of efforts. Lordship, however, our issue pertains to the great pay that we have been offered. Since similarly placed physicians and pharmaceutical technicians, they are getting paid a higher grade pay, Your Lordship.
Get your instructions here.
My lord, here page 39, Lordship may see, my lord. One of the prayer is for amendment of the rules. Probably it will be the division bench, my lord, if at all the rules come into force. Page 39, prayer 5,
Incorporating provisions for.
prayer number 5.
No, amendment of the rule, they're not challenging the rule.
No.
They're seeking a direction to amend the rules.
Yes, if at all they get the review. That, my lord, Lordship will issue notice in that case, it's great pay.
All right,
We'll have
heard
to file
other
a.
council for party issue notice. Returnable 4 weeks. Mr.
But I appear for all the respondents.
All,
Yes.
if he is for all the respondents, and therefore notices are waived, extra copies be furnished. Sufficient extra copies be furnished within a period of 1 week from today. Respondents in the meantime will complete their instructions and file necessary affidavit.
Much more. God bless.
My lord, that the council has mentioned he is neither for the petitioner nor for the respondent.
Why is he mentioned?
I don't know, it is only for him to answer. There are strange things happening, my lord. He is for the respondent.
Strange things are happening in the bar.
Yes,
So you
absolutely.
being a member,
Absolutely. Oh, no, I tried to
Sort it out.
locate that, my lord, that young advocate, I
all right,
could
all
not
right.
find.
Heard council for parties issue notice, returnable 4 weeks. This is an application under section 11(6) of the Arbitration and Conciliation Act 1996. The respondents are represented
Lordship
by
may reflect
Mr.
Mr. H. Gupta's name. Lord.
Huh?
Lordship,
H. Gupta,
H. Gupta.
H. Gupta, learned CGC, who is represented today by
Why Borbia, Lordship?
Y.
Borbia.
or we. Let the respondents file their objections, if any, in the application. Matter be listed after 4 weeks.
Lordship, in the cause list, the name of
H. Gupta may be reflected as an assistant solicitor.
The registry will reflect the name of Mr. H. Gupta for the respondents in the cause list.
I'm
Much
declared.
For orders, item 12.
Your Lordship, may kindly see the last order, my lord. It is reflected as respondent number 2, my lord. But in fact, it should have been respondent number 3. Respondent number 3 has been newly impleted, my lord. And so far as respondent number 2 is concerned, earlier we have submitted representation before him. It was duly received and.
Which is the order that you're complaining willful disobedience, page number 20.
Yes, my lord.
What is the direction?
Direction. Direction at page 23, my lord.
Minimum scale of fee.
Yes, my lord.
You are employees of social welfare.
Yes, my lord.
You furnished
Copies to all the containers.
copies to all.
Yes, ma'am.
Now, who is the respondent number 2 here?
Director.
Director Social Welfare.
Yes, my lord.
So you are supposed to,
We have already furnished. It is annexed at page 20.
you took time to seek instructions.
My lord, it was regarding container number 3, newly impleted.
Who is
Even
the,
then, my lord, we furnished
who is the newly implemented committee?
the finance, my lord. Your lordship may kindly see. We have filed IA for implement of container number 3, my lord.
So have you informed the, have you served copies to the finance?
Yes, my lord.
Where is that?
And this is the copy of reminder, my lord. We have initially
Where
we
is
have
the notice? Where is the application under which you have furnished to the, these people, departments?
Your lordship. And there was an office note for await service report, my lord. So subsequently, we have again, my lord, furnished them copies, my lord, by registered AD. This is the copy, my lord. We have furnished another reminder, my lord. Earlier, we have submitted on 22/12/2023.
This
And
is to the chief secretary.
yes, my lord. My lord, to copy to all, my lord, your lordship,
No.
this is the copy, my lord.
Copy to all is different.
The principal secretary, director of social welfare commission and secretary.
This particular notice does not reflect so. Page number
I
10.
have not annexed, my lord. This is the copy.
You
my
bring it on record.
Yes, my lord.
Bring it on record. There is an order that you are to, you are taken time to seek instructions.
Instruction.
Now, if you received it, bring it on record.
It may be corrected, my lord. Respondent container number
We
3.
correct it, you bring it on record first.
Yes, my lord.
In the IA, Learned Counsel for the petitioner, raised for further
1 week.
1 week's time to file an additional affidavit to bring additional documents on record.
Lordship, I'm for responding 1 and 2.
Mr.
R. Sahni on behalf of DNAT.
On behalf of Mr.
DNAT,
Dinath,
Deepak
appears for respondents
1 and 2.
1 and 2.
Oblige me.
This matter we have filed an I. Initially, the writ petition was on the basis of the fact that the petitioner who was employed was a storekeeper, was actually given a grade pay of 6,200 from 2017. Suddenly on 7/5/2025, his grade pay was lowered from 6,200 to 5,600. And therefore his pay scale also came down. So we came before this honorable court because at that point of time, even his salary was stopped. When we came before this honorable court challenging the reduction in the pay scale, and on my learned friend's assurance, the court ordered that salary may be paid, and thereafter his salary has been paid, but he was paid to the lower pay scale. Now, your lordship, that part is there. During the pendency, your lordship, before even filing the affidavit, again, there is a there in this writ petition that no deduction should be made. Now, immediately after that, after the notices, and we have been receiving the salary, no doubt. Now they have issued another notice that was, your lordship, find in the IA at page last page of the I, Annex 16. Now they have issued to refund the amount of rupees 1,04,000 something. Now that is why we have came by filing this IA, so that your lordship, before a decision is made taken on the basis of whether the deduction is correct or not, their refund, your lordship, at this stage this may be stayed.
This is after filing of the writ petition.
After filing of the writ petition, after the assurance given by my learned friend, when the salary has been paid thereafter. Your lordship will see initial instructions were taken on the first date. On the next date, my learned friend gave assurance. And then the salary was also paid.
We will issue notice, it's a fresh.
But
IA.
only thing, your lordship, this
You want to
part
file
with
any
regard to
objections?
this, I have a interim prayer here. For at least till the next date, suspend this, your lordship, deduction without even.
We know, we've seen your interim.
Yeah.
We are asking you, are you filing any objections?
Yes, madam, we'll file a objection, madam.
All right,
And
I
that-
heard Mr. Y.S. Manna.
Lordship, may I
counsel for the
submit-
petitioner, Mr. S.P. Das. Counsel for the applicant in the IA. Mr. S.P. Das for,
He is appearing for, I
2,
think,
3 and 4, madam.
huh?
2, 3 and 4, madam.
No, not to, in the IA. There are only 3 respondents,
Yes, madam.
opposite parties.
Yes.
Director.
2, 3 and 4, madam.
What do you mean 3 and 4?
Director Superintendent of
In the IA.
I.
I also, madam.
How do you turn to the next page? Page number 4. Okay.
Oh, madam.
These
Yes,
are
madam.
the 3.
Not, 2 and 3, madam.
2 and
2 and 3.
2 and,
Yes.
in this case, 2 and
2 and 3. Well, Mr. T.C. Sutia appears for respondent number 1. The petitioner before this court has challenged the, which order you are challenging in the writ petition?
In the writ petition, your lordship, order dated 7/5/2025.
Page number 62.
That is at page number 62.
62, madam.
The challenge, the communication dated 7/5/2025 within bracket annexure 7 to writ petition WPC number so and so. Stopped by the said communication, the petitioner, the director, employment and craftsman training, issued instructions to senior principal / superintendents of ITIs to thoroughly scrutinize service books of storekeepers serving in the establishment. And in any case, they are found to be drawing the grade pay of rupees 6,200. Then the same is to be refixed by taking, then the pay of such incumbent is to be refixed by taking grade pay of rupees 5,600 with effect from 1/4/2016
2016.
as per ROP 2017. And overdrawal of the pay is to be worked out and deposited in the government account. Stop. This court. On 25/6/2025 issued notice of motion. There was no interim.
No, madam. No, madam.
Interim was not there, but at that point of time, salary was not paid. So there was
Stop.
at the assurance
The-
of my learned friend,
the-
the court.
During the pendency of the writ petition, a subsequent communication being 10th of July 2025 has been issued by the superintendent of the Industrial Training Institute, Borpeta, where the petitioner is employed for refund of the excess amount which the authorities claim that the petitioner had received by drawing his salary at a grade pay of 6,200 instead of 5,600 with effect from 1/4/2016 to 30/05/2025. Stop. Being aggrieved, the present IA has been filed. The counsel for the respondents submit that they would like to seek complete their instructions in the matter accordingly. Let notice issue, returnable 4 weeks. Mr. S.P. Das appears for 2/3. Mr. T.C. Sutia appears for respondent 1. Or you can say, I will really issue, you can say that they've already accepted notice, therefore notices are waived. However, extra copies we furnished within a period of 1 week. Until further orders, the communication dated Now, until further orders, the communication dated 10 July 2025, seeking to recover the amount of rupees 104,160 from the petitioner shall remain state. List after return will date, along with the accompanying writ petition.
Obliged.
But as you know, as for this ROP, my lord, it was wrongly written as 6,200, my lord. That's the error,
But we
typographical error, my lord.
You will find.
Let them file the appeals.
I will file that.
Recorded as an audio.
Factually, we have placed everything. Factually, there is nothing. Only today, I would like to place some decision only on the point, Lordship to decide. Number one, Lordship, that cabinet decision 2013 is not yet implemented. That is the point. So on that point, as per order dated 4/4/24, that is Lordship, some queries were made and it was directed to the respondent to file affidavit. But till today, that affidavit has not been filed, no record has been placed. In support of this, I like to place division bench judgment of our High Court regarding this non-filing of the affidavit. Division bench judgment of our High Court relying on the Supreme Court judgment. That is one. And non-filing of the affidavit, none that is there. The specific question were put by the Honorable Court to clarify that position. Till today, it is not clarified. That's why I filed this affidavit, this judgment. Next judgment, Lordship.
No, you tell us, what is the judgment about? For what purpose?
Non-filing of the.
Read the paragraphs.
Yes, Lordship. So 1998, 1 GLT 544, here. Pleadings denial of by specific and not evasive. Allegation of fact, if not specifically denied, would be deemed to have been admitted. Necessity of pleading not only facts, but evidence in proof of suspects emphasized. This is the.
No, you are reading only the head note.
Lordship.
If you are placing the judgment, you have to tell us
Yes.
What is the
So,
context in which it was issued?
So here, our case is that the Honorable Court has passed an order on 4/4/24 regarding, so there's our allegation that the court has made inquiry on the specific subject. So that this is not submitted as yet, Lordship. So the direction of the Honorable Court to file an affidavit, it is not complied. That is my estimate. So paragraph 4 of this judgment, it is cardinal rule of pleadings that the denial has to be specific and not evasive. Every allegation of fact, if not specifically denied by necessary implication, it will be deemed to have been admitted. The Supreme Court has occasion to consider and deal with the aspects of the matter, albeit in a different context. It was a case relating to a land acquisition, but the principle laid down is equally applicable to the case at hand. It is reported that AR 1988, that
Is it anybody's case that there was no cabinet decision? They have not denied.
No, not that.
It is.
Not that, Lordship.
Is it their
Kindly,
case?
Lordship, go through that.
What is
order
that?
dated 4/4/24.
What is the direction of the court?
4/4/24. That's fine.
4/4.
4/4/20. Last paragraph.
So according to Mr. Nayak, this 55 names are not part of this 5170.
Probably it was there in the 5170, but subsequently in 2021, when the first notification came, therein the number was 1600. They were already out in 2021. In 2025, that is the second notification, Lordship, which was enacted by repealing the first one. There the number is 1000.
No. But we are not able to understand is your claim was approved in the cabinet. Cabinet decision after being taken was not implemented.
Not.
Subsequently, as it stands now, in 21 or 25, some act has come up.
Yes.
Now, this act has a categorical provision.
No, that also I raise a one point, Lordship. Whether the act is presently, the act is implemented
No,
on 25.
You have to address your arguments with some authorities if you have to show that once a cabinet decision is taken, until and unless it is revisited or
Yes,
recalled,
I'll submit. I'll submit.
they are bound to implement it.
That I'll submit.
Yes.
So here, Lordship, that till now they have not filed a affidavit, that is fine. And next is, Lordship, that cabinet decision, once it is taken, that is 213 3 SCC 559, that is I have heard it. 2013 3 SCC
559.
559. 519. Yes.
Yes.
Here, paragraph 19. Lordship got it.
Yes.
So, Mr. Venugopal, learned senior counsel for the contesting respondent, may be relied on the principle laid down in State Bihar versus Bihar Rajya Sabha. The said decision also arose from a dispute concerning the absorption of about 4,000 employees working in the teaching and non-teaching posts of 40 colleges affiliated to various universities, which were taken over as a constituent college in accordance with the provision of Bihar State University Act 1976. It was content. I skip up that next 64 paragraph, 64 Lordship. So far as the order dated 18/12/89 is concerned, the state being the author of the decision, merely because it is formally not expressed in the name of governor in terms of Article 166 of the Constitution, the state itself cannot be allowed to resile or go back on that decision. Mere change of the elected government does not justify dishonoring the decision of previous elected government. If at all two decisions contained in order dated 1/2/88, 18/12/89 were not acceptable to the newly elected government, it was open to it to withdraw or resign the same formally. In the absence of such withdrawal or resign of the two orders 1/2/88 and 3, it is not open to the state of Bihar or state of Jharkhand, which has been created after reorganization of state of Bihar, to contend that those decisions do not bind them. That is the paragraph, Lordship. Now, Lordship to decide, because today only I like to place only decision, because factual position, Lordship, I have already explained.
Yes. But this is not exactly on the point in which.
But Lordship may take in, because that's idea.
See, Mr. Counsel,
Lordship.
we are raising you a question.
Lordship.
You see, it's a plain and simple case that there was a decision taken. There's no denial on this. There's no dispute even by the respondents. It is their case that subsequently
Not that.
The government of the day has brought in
They brought one legislation.
legislation.
So
Now, in view of this-
in that point, let's see, my humble submission is, whether that legislation is a given retrospective or the prospective, that's to be decided by the constitution.
No, that legislation on.
No, legislation, because it is specifically in the legislation that is not there. That's why.
No,
Have
the
date of effect.
legislation clearly says whether it is date of effect is from which date is a different issue, but legislation, there is a section, if I remember correctly, that only with regard to people who are in service from a certain date in 2014. It will cover only those people. Now it is your case that you have already retired, long retired.
No, long retired, but as per the legislation, our appointments are prior to that, that is. And regarding retirement, Lordship, that I have already, yesterday I have already submitted a decision of Gujarat High Court that even after retirement, they are entitled. That is Supreme Court also says.
No, they are
Now,
entitled.
Lordship to decide, because my duty is to.
We are to decide on the issues raised. Your issue, you are not crystallizing your arguments.
I am relying the decision.
You are relying it, but you are not crystallizing your arguments.
Lordship.
You have to crystallize your arguments if you are placing on the judgments.
State government notification, there is no notification.
No notification as yet, regarding the act. Lordship, it is here, Lordship, on the preamble, it is nothing is there. Section 1.
Where is the
legislation?
What do you call the objects and reasons?
Lordship, I think in the record, Lordship will file one bill, Lordship, prior to.
It was
Motion direction by South 25 to থাকিব পাৰে।
It is not yet notified.
The
The act
bill is
yet
not required to notify it. What is?
No,
final
act-
is the ultimate.
Act has not been notified.
Not been notified.
No, notified, Lords. 2025 has notified. 16 June 2025.
Act has been notified.
No, act has been notified the day of force.
That is
From
also
the
there,
day
from the date of coming into
It
gazette
is not there.
notification.
It is not. On Thursday, the state government may be through official gazette appointed different date, may be appointed for different provision. That is 1-3 says.
No, that date is there from the date of notification. Or from any other date, government, if government.
What is that section?
1-3.
That in which 2000 up to 2014 people are.
Lordship 3-1 is one and 4-3 is one.
4-3. The 4-3 is not yet implemented.
No, 25 has already been, it's an act, Lordship. Somebody can claim under that act. It will give somebody.
No, even if it is an act, sometimes certain provisions are not implemented.
No, Lordship, if it is an act, Lordship, and those persons are covered by that act, they can claim a right under that act. What I am submitting, Lordship, so far as the petitioners are concerned, a decision was there. Probably initially they were covered by the decision of the cabinet. But subsequently in 2021, when the first notification came to be enacted, Lordship, at that point of time, they were not there in the 2021 because the number came down to 1600. They preferred not to challenge. Even in 2021, I found one representation by the association, Lordship, requesting the government for notify the cabinet decision of 2013. That representation is also here, Lordship. In the I think, Lordship, that 2025 bill is not here.
Give us the reasons, statement and objection.
Lord, it will be there in the bill,
You
Lordship.
get it and
that has been placed before the.
You give it to us.
Lordship,
wherever
that
it
can
is.
be placed, Lord.
Wherever it is.
It has to be there. Generally there, it remains there. You find sorry, 25 is a negative. 25 file here, my lord. 25 খন নাই। Notification খন আমি বাহিৰৰ পৰা উলিয়াই। Lordship, that 2025 is not here.
Excuse me, Lordship.
Yes.
Lordship, statement of object and reason, the soft copy, Lordship may go through this.
বিলখন পাইছে, বিলখন পাইছে, বিলখনত থাকিব সেইটো।
You have a copy?
Yes, that's a soft copy, that's a. Objection reading.
Get a printout. Why are you giving us?
The network is not very stable.
Okay, we get a copy. All right. You give us a copy, we'll examine that. Heard counsel for parties. The matter has been heard. Counsel, you have submitted before this court. Records are also furnished before this court. Stop. Only on the question of court, on a query made to the state council as to the objects and reasons of the statute which was enacted by the state. What is the name of the statute? What is the name of that act, new act?
Yes. This is the Assam Municipal Employees within bracket Provincialization Act to
As-
2025.
Assam Municipal
Employees
Employees within bracket Provincialization
Act, comma 2025.
2025, which was implemented with effect from
From the date of notification, that is 16th of June 2025.
16th of June 2025. Let this, the counsel for the respondent, comments that you would like to